So let me introduce our colleague, Mel Barnes, who is staff attorney at Law Forward and one of the leaders of the citizen litigators who have been fighting for fair maps in the courts. Good evening, Mel.
Hi, everyone. Thanks for joining us.
So, Mel, why don't we just start with this simple question. What happened yesterday? What happened in the U.S. Supreme Court?
So something pretty surprising and unexpected happened. The U.S. Supreme Court decided to step in and interfere with Wisconsin's elections at this honestly very late date. Some of you are probably thinking, okay, we don't have, elections until the fall, primaries aren't till August, but one of the things that's been driving the timeline of the litigation around redistricting is that there's so much work that clerks and candidates and voters even need to do before we can hold elections. So the Wisconsin Elections Commission had started administering elections, started putting the maps selected by the state Supreme Court into effect already. So this really is a late interference by the US Supreme Court. And it is really surprising and unprecedented because in several other states already, just in the last month, they've declined to put maps on hold in states because of the late stage in the election process. I want to be clear.
That just happened less than 2 months ago in Alabama, right?
Exactly. And we've seen North Carolina and Pennsylvania since then, both places where the court said it was too late to be tinkering with maps.
So what do you think was different about this case? What is your observation why the U.S. Supreme Court stepped in so late in our election process, just 3 weeks before signatures have to be gathered by candidates for the state legislature?
I can't tell you that there is a good reason. I think that all of the other states that I mentioned raised similar types of claims, similar issues with the Voting Rights Act, and it really is unprecedented that the U.S. Supreme Court would step in here in Wisconsin. Now, I want to be clear that they left our congressional maps in place. So we're just talking about state assembly and state Senate maps tonight, but that's a huge part of administering the election here in Wisconsin, right? We have 99 assembly districts and 33 Senate districts in our state.
This question, but people have said that there is one through line between Alabama and Wisconsin, which is that in both cases, the beneficiaries were the political allies of the majority of the U.S. Supreme Court. Do you have anything you'd want to say about that?
Well, I would say, even more than political allies, in all of these cases, the maps that have been put in place or not tinkered with, or in our case have been tinkered with, have advantaged white voters. What the U.S. Supreme Court did here in challenging the validity of the 7 Voting Rights Act districts that the governor's map drew in Milwaukee is taking aim at minority communities that have been historically excluded from the political process in Wisconsin and nationwide. Whereas in Alabama, when those same communities, voters who looked like those people, were saying, hey, these maps are unfair to us, the court said it's too late to change the maps.
What is the kind of best case scenario from the perspective of voters who want to see the fairest maps possible?
Yeah, I think this is a really logical way to walk through it. So look, we know that we're stuck with this least changes approach, right, that the state Supreme Court did. And I think, we all had some conversations about this when the court originally selected the governor's maps, that these maps were the best case scenario, the fairest maps that we were going to get under this least change approach. So I think that continues to be our best case scenario, is that the state Supreme Court says, okay, we've heard from the U.S. Supreme Court, they want us to do more to show our work, but these are still the maps that we're selecting. They still outperform any other submission on this least change criteria, which is what the court said to begin with. And we're going to add some evidence to our opinion articulating why these are the maps. So the best case scenario is that we keep the governor's maps adopted by the state Supreme Court, and they go back into effect in Wisconsin in a matter of days or weeks.
So let me just highlight 2 things I think that you said there. So one is we have to remember these maps are gerrymandered. They've been gerrymandered in favor of Republicans for the last 10 years by using a least changes framework. Whichever one of the submissions they chose, the maps were still going to be gerrymandered. But amongst those gerrymanders maps, there were some pretty significant differences. The Republican legislature proposed a map that would deepen the gerrymander, that would make it worse. And they would almost guarantee in almost every election scenario that Republicans would have a 2/3 majority in both houses of the legislature. So even if a Democratic governor was elected, the Republicans would be able to override them on everything, right? That's the map that the legislature proposed.
And I want to be crystal clear. The record supports that Milwaukee should be drawn in a way with 7 Black majority districts. The evidence that we and the governor and other legal teams put into the record, that is there, and we stand ready to supplement it for the court if they have questions. But if the court is not convinced of that, if they want to see a 6-district configuration, what they could do is say that, okay, we're going to set the governor's maps in place for the rest of the state, everything other than this handful of districts in Milwaukee, these VRA districts and kind of the immediately neighboring districts. And we just want the parties to propose different ways of drawing this little cluster around Milwaukee that would fit into the governor's overall map. Because remember, the rest of the map, the vast majority of these districts, were not implicated at all by the US Supreme Court's decision. So I think that would be the next fallback option if the court, for some reason, thinks that only 6 Black majority districts are required, to have parties submit options for that configuration that fit into the rest of the governor's map that was already adopted by the court.
That's really great. We're just going to take a couple of questions about the larger implications for the Voting Rights Act. Could you just take a minute or two? This has been worded in the questions as it feels like the VRA has been turned on its head. Are they trying to get rid of the rest of the VRA? What do you think about that?
Yeah, I think I want to connect this to a lot of broader conversations that are happening in our country and in our culture right now around how we address lingering issues around race and the country's history. And we're seeing a huge push from certain conservative forces to say that we just need to be done talking about race, that we never need to consider it, kind of a push back to this colorblind anti-racism theory that I think comes from the 1990s. And this is what's happening to the Voting Rights Act right now, and this push to have it reconsidered by the US Supreme Court. I do think that there is a real danger to the Voting Rights Act, which is one of our just most monumental pieces of civil rights litigation in this country, and such a victory to have it passed. There's a real danger to that piece of legislation right now at our US Supreme Court. They don't need to take this case from Wisconsin. They don't need to mess with our maps here to really roll back the protections of the Voting Rights Act. There are other cases they've already agreed to take, including this case from Alabama, that they could use to really limit the existing protections and scale back what this law was intended to do and what it has been doing in our country for decades now. So I think we have lots of advocates around the country looking to strengthen that legislation through things like the John Lewis Voting Rights Advancement Act that's pending in Congress, and looking for ways to really strengthen the legal tools available to advocates and to all of us to make sure that we don't lose this monumental piece of legislation that has been so important to addressing systematic issues of discrimination in our institutions as a country.
One other question I want to make sure that we answer respectfully, which is a couple folks have asked about the impact on Latino voters, and we don't want to leave Latino voters out when we're talking about African-American voters. The reality is that the circumstances are different, because even though there are more Latinos in Wisconsin than there are African-American voters, they're much more spread throughout the state. And so there's only 2 districts that are implicated by the VRA, both on the near south side of Milwaukee. One is a majority Latino district. One is very close to a majority Latino district. Those districts are not necessarily impacted by this litigation, but Latino voters broadly throughout the state are impacted just because the map is gerrymandered, right? So even though those densities don't exist for Latino voters in their population distribution the same way they do for African Americans, there still is an impact, obviously, on the state. And so we really do appreciate that question. It's important to note that there are 2 districts that are impacted by the VRA that are Latino districts. We expect under any of these solutions there will continue to be 2 districts. So let me just kind of conclude with one thought, and then Mel, have you maybe respond to this, which is in the grand scheme of things, this is a big deal, right? And what do you think the impact is, not just on our map, but the larger picture of redistricting litigation when the Supreme Court just comes out of nowhere. We don't even know who wrote this decision. There's two people on the dissent. We don't know if other justices potentially voted against that decision, but just didn't decide to sign on to the dissent. It seems like one justice might be in the hospital. We have no insight. There was no oral argument in front of the U.S. Supreme Court. It just literally dropped out of nowhere. What do you think about the process question and the implications of how this has happened?
Yeah, I think that, redistricting this cycle, there's been a lot of talk around the country about, because of the census data delays, everyone has been forced to kind of do this work faster than they otherwise would have. And I think that the Wisconsin Supreme Court, had their own struggles with trying to figure out how they were going to manage this litigation ahead of this kind of March 1st deadline that they were working towards, and, ended up setting some very tight timelines for briefs, but hearing from the parties, many parties, multiple times. The U.S. Supreme Court didn't have that record before it. Like Sachin said, they did not take oral arguments. Doing this sort of damage and making this dramatic reversal on the shadow docket, I think is really harmful, especially when it's so close to our elections. But I think the two things that I want to say to everyone who's trying to kind of wrap their head around all of this as we wrap up here is, I know that there's a lot of uncertainty right now. There's a lot of uncertainty about what happens next until the Wisconsin Supreme Court says what they're going to consider, how they're going to go about this process. So I'm sure that you're all feeling that, we are feeling that. But what I want you to know is that the folks who are litigating this and all of the fair maps advocates around the state, we have a plan. We are going back to the court. We are not, resting for a second here. We are going to continue this fight for fair maps. And right now that means getting fairer maps so that we can continue the work that we've started and carry it forward, and doing the best that we can with this Supreme Court and this least changes approach. But we are back in court. We will know more soon. So while I know that this is a really stressful time to have so much uncertainty when we really thought this was settled in Wisconsin, I want you to know that we will have more information soon.
Thank you again, Mel, for having this colloquy with us tonight.